Welcome to the IR Digital Podcast, a part of IR Global, the largest international professional services network. I'm your host of the IR Digital Podcast, Jennifer Riggins. Today, we're sitting down again with Michael Einbinder, founding partner of New York City-based business law firm Einbinder and Dunn LLP, with extensive experience both in representing clients and acting as an arbitrator. Definitely check out our previous conversations in the same feed right here that you're listening, where we talked about the importance of documentation as a contingency plan for, well, your whole business. And when we get into all things franchise law, from the tiny franchise org to a giant one to the franchisees. Today, Michael and I are talking about a hot legal topic in the world of ever-changing employment, non-compete clauses. Hi, Michael. How you doing? Always a pleasure to talk.
Good morning, Jennifer. How are you today?
I'm good, thanks.
Great.
For those who haven't listened to our conversations yet, please share a bit about yourself and your notable experience for this conversation.
Sure. Well, as Jennifer said, I am an attorney in New York City. We have a broad-based business practice representing clients in transactional work, including shareholders agreements, acquisitions, contracts of every kind, relationships between businesses and their employees, et cetera. All of that on the transactional side and more. And we also represent clients in litigation and alternative dispute resolution, meaning arbitration and mediation. And as you said, I'm also an arbitrator, generally with the American Arbitration Association, where I serve on as a neutral in connection with business disputes, generally in all sorts of different fields. But a lot of that work is in shareholder disputes and internal company disputes.
Okay, very interesting and very plausible or applicable for today. So let's start with a baseline definition. What is a non-compete clause versus a restrictive covenant?
Yeah, so restrictive covenant is an overall broad term that represents a wide variety of agreements entered into between parties that restrict conduct in one way or the other. In the case of a non-compete, it generally restricts your ability as a person who signs this from being able to compete with a former employer by going to work for a competitive company, from competing with a business that you might have sold. And in the field of franchising, where we do a lot of work, it restricts you from competing in the same business that you were in when you were a franchisee of, say, a restaurant business. It'll stop you from competing in a similar restaurant field.
So any type of restaurant in that situation, or it would be like Greek restaurants?
Well, that begs the question, Jennifer. The most important aspect, and one of the most important aspects of that comes up in legal issues relating to non-competes is whether or not the business that you are prohibited from competing with is truly, the new business you're in is truly competitive with the former business that you were in. So in a franchise context is, whether you're working at a pizza place or a high-level executive at a company that owns a number of pizza restaurants, whether or not working in a different restaurant field, let's say for breakfast food or for fast food or something like that, you would, whether you should or can be prohibited from doing that. And from a drafting or writing the agreement standpoint, what's the best way to handle protecting intellectual property and other things when you want to have someone restricted from some kind of activity related to the restaurant field, as an example. But again, to continue the kind of discussion about the broad base of things that I'll talk about today in the restrictive covenant world, the other thing that's important, I think, that comes up very frequently in my practice as both an advocate and as an arbitrator is about issues associated with trade secrets. Mm-hmm. And non-disclosure agreements and trade secrets sometimes go hand in hand, but generally speaking, trade secrets can involve former employees, lawsuits against former employees or claims against former employees, but for sharing information about your business with the new company they work for, or taking the trade secrets that they've learned from you and using them in some other way that's outside of the scope of their former employment or current employment for that matter. So I'll talk a little bit about that. as well.
So Willy Wonka and the Chocolate Factory and the
Sure.
everlasting gobstopper comes to mind, of course.
Okay.
So who would be interested in this conversation? And is it the same in all countries, all states?
Yeah, so I have no idea who would be interested in this. I hope everyone is. But it's an interesting topic to me, and something I've spent a lot of time, both topics are interesting to me, and it's something that I've spent a lot of time addressing as both an advocate and an arbitrator. What I think is interesting about this for the IR Global public, if you will, for the members of the IR Global and their clients is who's impacted by these things and where I can speak about these issues. So I'm going to tell you right now that I'm going to speak about these issues only in the US. What I've learned in part from my involvement in IR Global, but it's not surprising to me, is that different countries have different rules. And quite honestly, I don't know what those rules are unless I've come across it for one reason or another in my practice in the US. And one prime example of that is a client that I was retained by, who was referred to me by an IR Global member, and that client was not in the US, was starting to do business in the US, and we were hired primarily to set up their business in the US, forming an entity and dealing with the paperwork related to that, and pretty much nothing else. And within a week or so after we got hired to help them set up a branch in the US, they were sued because they hired someone in the US who was subject to a non-compete agreement from their former employer. And the first thing my client said to me is they're not used here. We don't enforce, we don't have non-competes. We don't even know what that is really, although I've heard the term. He said, we've never had to address this and we don't think about it. And that sort of got me thinking about what's the impact of these rules in connection with, or the applicability of these rules in other countries. And so I don't know, and I've never done a survey of what the rules are outside of the United States. But I deal with this on a fairly regular basis for clients in the US and for clients who are outside of the US who are going to do set up shop in the States. As to the question of what's applicable, sorry to interrupt you, what's applicable here or what laws apply, they are different here from state to state. Not surprisingly to me, but maybe surprising to people who don't practice here. And there's a wide variety of differences, so much so that it's pretty straightforward when you're representing somebody that you should look at the state laws that might be applicable to your non-compete or your trade secret claim or claim against you, so that you bring that case in the right jurisdiction. There are some federal rules that are implicated. There are state rules and laws and cases that are always applicable to these things. I can give more detail.
In the situation, when you're saying state laws that are applicable, et cetera, is it the location of the company or the location of the employee? As we often are working with distributed companies, or the location of the business, like the individual restaurant versus the location of a lot of most companies in the US seem to be either California or Delaware incorporated. So how does that affect?
Yes, is the short answer, or it depends is the short answer. So I mean, when you're practicing for as long as I have, you tend to have war stories, and they sort of prove the point, and they establish kind of the context of that gives you an answer to this question. I represented a client who was based in Wisconsin, who had an employee who was based in Vermont, who was being sued by a company that was incorporated in Delaware, but located in New York. And we were threatened, the client and the employee were threatened with a lawsuit relating to non-competition. And what we wanted to do is we wanted to beat them to the punch. We wanted to go to court first. It's often a tactic that is used in these contexts. And we examined the law in each of those 4 states that I mentioned. And we found that Vermont, where the client was located, was the friendliest to its employees. So we brought suit in Vermont to stop the enforcement of the non-compete. The other side said, well, Delaware law applies. And then said, well, New York law applies. And I said, well, he's an employee in the state of Vermont, And the public policy of Vermont has a strong, is strongly in favor of employees. So Vermont's the best place to litigate this. And we ended up in Vermont, and it was helpful to our case.
And you got to decide that?
Well, I got to decide that by filing the lawsuit first.
Fair
My
enough.
client was sued, they would have been sued in Delaware or
Okay.
New York. So we started the lawsuit first in Vermont, primarily, or in substantial part, to try and get a good forum for the law that we wanted. Technically, I mean, there's a whole bunch of competing issues about what law applies to a particular dispute. Sometimes that is determined by what the agreement says, and sometimes it's determined by public policy, and sometimes it's determined by where you file suit. So we took advantage of what we thought was the best approach to this and filed suit first in Vermont to cover the issue, which sort of raises the question of what states are best and why, you know, one law is better than the other and what's happening in this field. So I'll let you ask the next question before I go on.
So does the size of company or industry matter for this?
You know, it tends to a little bit. I mean, you know, I haven't done an exhaustive survey of cases in this field, but, you know, I've read that small companies are more likely to be successful in pursuing a non-compete claim than larger companies. And the higher level the employee, the more likely that they are to be able to enforce it. The underlying theoretical notion of non-competes, in addition to the law that applies to it, is really what I focus on in litigation on both sides. It's one thing to say that someone should be prohibited from, broadly saying that someone should be prohibited from working for a competitive company, if we're talking about an employment case. It's another thing to not to have a reason why that's important. And then we'll talk about it a little bit later, but that goes into what you do when you draft an agreement, because the best way to show that something's important is by putting it in the agreement and saying, it's really important that we be able to enforce this because, and that because generally is because in your employment at company XYZ, you're going to be provided with confidential information, competitive information, trade secrets of the company, and you're going to learn a lot from us, and we don't want you to use it somewhere else because that's on our dime that you learned all this stuff. Just blanketly putting in, you can't compete, kind of hurts you. So a smaller company that has a larger stake in an individual employee who represents, 20% of the workforce, or 50%, or 10% of the workforce of 100, of a company with 10 employees, is a lot different than a 30,000 person law company that has one employee that they're pursuing this against, when that person is just a cog in the wheel. That changes, the dynamics change when the employer is higher, when the employee is a higher level.
That's interesting because I think most startups, at least more in my tech space purvey, aren't doing that yet because they haven't thought that much about it. It's the more sophisticated or mature companies that are actually thinking about having this into their contracts. And once it's signed, you can't redo an employee contract to have that information in it, can you?
What's two questions? I mean, the first question is, I actually see it in a lot of tech companies because they're particularly concerned about their technology. And that has such value, and that is the significant, most important value of a tech company when it starts. Everything else is moderately immaterial. I mean, aside from customers, but customers sometimes are public-facing information. So what the tech is really, really important, and stopping people from competing is sort of critical in that arena. Time for a second. What was the second part of that question? I forgot what you asked me.
It was just if you can change and update the contract while the employment continues, or if they change jobs within the company.
Yeah, let's go back on. So the question of whether you can change it is actually different from state to state as well. Some companies hold or provide some laws, I should say, some state laws provide that a non-compete is only enforceable if it's signed before you start working for a company. Some states have regulations that require the non-compete to be provided to the prospective employee at least 2 weeks before they start. Some states don't have this rule. The companies that require you to sign after you start or significantly after you start have a harder time enforcing these things because the employee had no bargaining power. They were in a job already. They didn't take it as a condition of employment. They took it as a condition for continuing employment. They signed it as a condition for continuing employment. There's an element of, I wouldn't say coercion, but there's an element of being compelled to do it because you had no choice at that point in time. And so it becomes somewhat less enforceable. So it makes a difference. When you change jobs within a company and get a higher level of status, then maybe you redo your employment agreement and say you're getting this new job, and in this new job, you're going to be exposed to more stuff that's important to us, more trade secrets, more competitive information, and therefore you have to sign a non-compete. Those are the rules. Those rules recently have changed a lot, and if we want to talk or about to change, or they're changing state to state in a way that's not entirely clear at this point in time. I can talk about that if you want, or we can go into, you may have had other questions.
How does it work then when you're dealing with lower wage or hourly workers? A lot of the fields we're talking about, like, I don't know, a secret ingredient at a restaurant chain or a franchise. How does it work then? These are not people that maybe are as, well, probably most people don't go to law school and have this understanding and this legal literacy to consider a contract. How enforceable is it then?
Listen, sometimes a non-compete is within a series of documents you sign when you first start working someplace. So maybe you're not looking or not that careful about it as an employee. You're bound by whatever you sign, but you may not have been so sophisticated that you looked at every document you're signing. If you're particularly if you're an hourly worker, a low wage earner. This is happening a lot in certain kinds of industries where there's a move against the enforceability of these things, or certain states. So, for example, California is a sort of a leader on the liberal or more progressive side of this issue. For a long time, non-competes in an employment context and generally have been unenforceable in California. Some other states are adopting those rules, and the Federal Trade Commission is looking at whether or not it should be adopted nationwide. But in say the fast food area, where a lot of my franchise clients are involved, there has been regulation in some states that franchisors can't enforce what's referred to as non-poaching provisions. So if someone's employed as a line cook in a fast food restaurant, they might be prohibited from going to work for a similar fast food restaurant across the street. That the restaurant across the street can't poach that employee, hire that employee, and that's really had a significant impact on the mobility of workers and mobility, according to the laws of certain states or regulations, affects wages. And so some states, notably, let's say Washington State, prohibits you from putting in your franchise agreements these no poach provisions because they impact low wage earners. The thing, getting back to the question here, large company, small company, higher level jobs are more likely to have these things be enforceable. There's got to be some basis, in my opinion, or rationale, depending on where you are state by state, for enforceability of these things. In the case that I was in, that I mentioned, where I got a company coming into the U.S. for the first time and hiring someone, the law where the company was located that hired the guy that the guy used to work for, who was working for my client, was a state that enforced non-competes against everybody. Administrative workers, high-level executives. They had a reputation for doing that and filed hundreds of lawsuits against employees, including low-wage workers and administrative staff people. And I was surprised somewhat that there was that these cases were largely won by the employer, because you're talking about people who don't have the wherewithal to fight these lawsuits also. So, there are many instances in which these cases go unresponded to, and people are then fired because of it. Also, sometimes companies that are enforcing non-competes pursue them against the company that the former employee went to work for, and that's a detriment, or at least an incentive not to hire that person when they have non-competes. One of the things that we counsel clients on is to make sure they get information from the prospective employee about whether or not they're subject to any non-competes, and then we want to review them and make a decision about whether or not they hire someone who might be subjected to something or subject to something that's going to put you in the line of fire for the former employer. So it's a whole bunch of different things that come up in this context. Suffice to say that there are many different angles that you look at these things from. From an enforcement standpoint, if you're representing the client trying to enforce it, my advice, sometimes after the fact, is strengthen your non-compete documentation, have a rationale for it, pick the right state to pursue it in. If you have a choice of law, if you can put a provision in your agreement that chooses the law that applies, then you might want to put that law into your agreement. Florida is a very strong state for enforcement of non-competes. So you might want to use that. Those are some things you have to think about, but here's the most critical thing. And this cuts two ways. Does an employer enforce it all the time? Because the argument is by an employer, I need to enforce this to protect my company. And if I don't enforce it all the time, then apparently I don't care that much about enforcing these clauses all the time to protect my company. And it undercuts the argument that it's critical for the court to stop somebody from competing with me, and I lose my case. And if I'm on the other side of that case, or let me start with this. If I'm counseling a client, I say, enforce this every time something comes up, or lose the right to do that. Trademarks are a similar example. We do some work in the trademark field, and if you don't enforce your trademark rights, you lose them because you're letting people run amok with a similar name or something like that. So you have to worry about that. But on the other side, when I represent the employee or the company that hired the employee, one of the first things I look for is whether they're enforcing it across the board. And if they're not, it's argument one in my opposing, in the papers I file opposing an application to stop this guy from going to work for a competitive company, my client's company. So if this company did not enforce this every single time, it's not critical. They're not harmed by this.
And it could be almost prejudice against an individual that they're enforcing it in one situation, or against a company that they look at as more of a competitor.
Right. So what's referred to as selective enforcement. Mm-hmm. And that's an argument that you can make. It undercut. This is New York, and this is Madison Avenue.
Super New York.
It's a critical issue, the enforceability of it. And what you really argue, in order to be successful in court to enforce a non-competition agreement, you have to be able to show that the competition is going to harm you in a way that you can't get money for it. That money won't suffice to protect you. You have to stop this person from working there. And that's called irreparable harm. And you can't prove it if you haven't tried to do it every time, because you've obviously conceded that you weren't irreparably harmed by the last person who went off to compete against your company. So it's critical to look behind what's going on. And we've been successful with that argument.
Similarly, what if there are some employees you find out that didn't have to sign this? Maybe they negotiated that out or something. Does that then invalidate it for everyone?
I think it does, depending on who I'm representing. If I'm representing the company trying to enforce it, no, it doesn't make a difference at all. But if I'm representing the company against whom it's being enforced, or the employee against whom it's being enforced, then the fact that a company has not gotten every single person in the company that's at the level of the guy they're pursuing the claim against to sign this document is an indication that it's not that critical. And then you go into court or in arbitration or wherever you are and say, they're just pursuing it against me for whatever motive, but the bottom line is it's not important enough to them to rise to the level of irreparable harm, and therefore don't stop the guy from working for the new company. Don't stop my client or my client's new employee from working for me. And I think it's a pretty strong argument. So we go behind that. We ask for that documentation in any lawsuit. Give me a copy of, of every single non-compete agreement that you have. And then when I take a deposition to get information during the course of the case or send written questions, I ask if they enforced it all the time. And there were instances in which they didn't. And all these arguments can be made. And this comes up in the practice, in my franchise practice a lot, because there are kind of three arenas for non-compete analysis. And one is the employee. The employee is the least likely to be stopped from competing because people have a right to make a living and livelihood of families and, sort of that kind of stuff. Then the other side of the spectrum is company against company. So if I buy, or company against the former owner. So if I buy your business, and then you go on and sell me the business and all the goodwill and all the customers that were in your business, but then you go up and set up shop down the street and start competing against me, and I have a non-compete with you, you're undercutting the terms of our deal. The reason I bought this from you is so I have the goodwill in those customers, right? So if you take that away from me, you're really reducing the value of what I acquired, and I've already paid you that, and so I'm entitled to enforce the non-compete so that I can keep this business that I bought from you. So it's more likely to be enforced there, even in California in some instances. The one in the middle is franchising, because it's kind of the nature of an employment versus company kind of thing, right in the middle, and so you can argue a lot of the same things you do for employees. The other side will argue the same things that they would argue about selling businesses. But when we're representing a franchisee in a case like this, we often go to see whether or not the company enforced, the former franchisor enforced those rights, those non-competition rights against the other franchisees in the system, and have been successful in defending clients on that basis.
So basically you want counsel from the beginning, because otherwise, if you're not doing it right from the start, you're risking everything.
I absolutely agree with that. I think the counsel's twofold. One is make the agreement stronger and as strong as you possibly can, paying attention to the changes in law, which are fairly frequent these days. And secondly, to make sure that whatever rights you have, you enforce on a regular basis, otherwise lose the right to do that.
So how does this then affect trade secrets? What is a trade secret, and how can you prove that this person gave away this trade secret?
So as all things here in the States, there's not necessarily an agreement on what a trade secret is. So there's a United States federal law called the Trade Secret Act. There's what's called a uniform law that states can either adopt or not adopt. And then there's New York, which has its own laws. I don't know why. I have a suspicion of why. It's just that there are more cases in New York than a lot of other places, just because of the nature of business in New York. But at bottom, it's information that is not known to other people, that is specific to the industry, that is critical to the operation of the business. There are a bunch of different definitions, but that's what it comes down to. Is it important stuff? Is it you're the only one who has it? Is it scientific? Is it competitive? That kind of information. There's a lot of different definitions for it. The issues there are, regardless of where you are. First of all, the thing that you have to be concerned about always is to look at the law that applies the U.S. the trade secret law is new, and there's not a lot of case law on it. Newish in the last several years. The uniform law has been around for a while. New York law has been around longer. It's important to look at the cases that address this. It's important to look at the uniform law because it has a sort of more detailed analysis of what a trade secret is, because you can play with the nuances of this a little bit and kind of argue that it's not exactly a trade secret as fits into this. You can look at what's called a restatement of contracts. Restatements are these sort of descriptions of laws that give you an understanding of what they mean. Let's say common law, case law, or statutory law. These are all important things to look at. But here's the issue, and this is wherever you're litigating this or arguing this, is you have to protect it to make it a trade secret. Because if you don't, it ain't a secret. And and so what the case is, it depends what you're arguing. I handled a case a long time ago for a franchise client who was subject to a non-compete in the trade secret agreement, and a violation of a confidentiality provision in their agreement. So there were a lot of things I argued about the non-competition agreement, including the fact that the company didn't enforce it against its former franchisees all the time. So I argued that. I argued that my client knew this industry because he was in this industry for 15 years before he became a franchisee. So there's nothing he doesn't know about this. He knows more than you do, franchisor. And then I argued that nothing was a trade secret. And the reason I argued that is because what was allegedly a trade secret were all these manuals about how to operate this business that happened to be in the lobby area of the company that was available to anyone who was waiting for a meeting. And oftentimes there was no one watching someone who was in the lobby area looking at those things. So they could take the operations manual, for example, off a bookshelf in the reception area of this company. We had pictures of it, and they could look at that. So there's no trade secret there. And we were very, very successful for that client, very successful for that client. Case got mostly dismissed and settled for almost nothing rather than going to trial over a small amount of money. We got sued for $11 million. Came away with a very, 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 very small payment to the other side just to pay for part of some small portion of their legal fees, just to get it over with. One of the first cases in New York on trade secret cases in the Federal Trade Secret Act was one where the court went through a lengthy analysis of whether or not the information that the plaintiff in that case, which was a tech company, which was trying to stop a former employee from going to work someplace else, or trade secrets from being used by a competitor, was that all of this information that they were trying to protect was absolutely unequivocally within the definition of a trade secret, except for one minor problem, Jennifer. They didn't keep it secret. Everyone had access to it. There were no rules about who got to it. There were no agreements with half the employees in the company. That information was freely disseminated without any restriction, without any lock and key, so to speak. And the court found in favor of, found against the company that was purporting to have a trade secret because they didn't protect it. So they apparently did not see this podcast or hear this podcast and know that they have to protect it from the get-go. But it's the same sort of thing. I mean, these kind of things that revolve around knowledge, information, intellectual property, all sorts of things like that, whether, including trademarks, which you talked about a couple of minutes ago. But in the non-competition arena and in the trade secret arena are these things that you either have to protect or lose the right to protect. The best way to protect them is with agreements that are drafted to keep all of this in mind, or to be able to argue when you're in court to support your argument about non-competition or trade secrets or trademarks, and then to really enforce it on a regular basis. And by regular basis, I mean every time. Because if I'm representing the other side, I'm going to delve into that. That's a hole in a lot of cases. And so you have to go into it. Before we end, I just want to talk a little bit about what's going on in this field in the US. There is a move for the Federal Trade Commission is looking to change the rules around whether or not non-competition agreements are enforceable. This Biden administration is doing that here in the States. The terrain is going to change significantly for some level, it may change significantly for some employees. The idea is to promote competition, to promote mobility, as I talked about a little bit before. And I think that it's going to change significantly. I don't know that for sure, but I think it is. In the franchise arena, the FTC has been asked to look at whether or not the non-competition provisions of franchise agreements should be enforced or allowed. And the notion is that it's more, in some instances at least, I don't know if this is entirely accurate, and I don't know if I agree with the Federal Trade Commission's kind of approach to this, but the idea is that in many cases, franchisors are small business guys, small business mom and pops, and it's more like an employment situation than anything else. If you buy a franchise, you have a building, you house your restaurant, you stop operating as XYZ restaurant, and then because your agreement expired or terminated, or is terminated for some reason, and then you can't operate a restaurant at the same place anymore, even though that's what you do when you give a lease for the restaurant that extends for X years past the time the franchise agreement is over. So, you know, the FTC is looking at that. The world of franchising is not entirely made up of mom and pops. It's sometimes made up of very, very large companies. You know, there's a lot of stuff going on in that arena, a lot of questions. The FTC has asked for comments on this. A lot of people have submitted comments on this, and it remains to be seen what's going to happen in that field. But it is an issue that's been coming up. Anyway, you know, like I said before, there are a number of states that have restricted the enforceability. Illinois, Colorado, and others are some of them. California has always been one of the leaders in that world. If you think of that as a leading thing. There's a lot of different versions of this rule, and it's different from state to state.
So definitely keep listening to this podcast and our conversations, and follow Michael. Where do they learn more about you if they want to touch base? LinkedIn, your website, about your legal service,
website,
everything.
Our website is ed-lawfirm.com. So Einbinder, Dunn-lawfirm.com. ED. My email address is my initials, me@ed-lawfirm.com. For those of you who are listening that are part of IR Global, or look at the IR Global website, there's a way to find me by looking for an advisor in New York. We do a lot of work in this field, and be happy to help anybody who has a question about any of the issues I've discussed today.
And there will be more questions because it sounds like it's a very dynamic and changing field right now.
It is.
Thank you so much, Michael, and thank you, listeners. These IR Digital podcasts are meant to be educational resources from experienced lawyers, accountants, and financial advisors. These trusted advisors you need that have the extensive knowledge on topics you as professionals need to know more about. To learn more about IR Digital and its services, please visit irglobal.com. And if you found this episode useful, please consider sharing it. You know the people who need to listen to this. Thank you so much.